Section 2 of A History of the Inquisition of Spain, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. A History of the Inquisition of Spain, Volume 3, by Henry Charles LEA. Book 6, Chapter 7, Part 2. The conditions held to justify torture were that the offence charged was of sufficient gravity and that the evidence, while not wholly decisive, was such that the accused should have the opportunity of purging it by endurance proportionate to its strength. From the inquisitor's point of view, it was a favor to the accused, as it gave him a chance which was denied to those whose condemnation was resolved upon. This is illustrated by a highly significant case in the Toledo tribunal in 1488. Juan del Rio had lived long in Rome, where he was present in the Jubilee of 1475. By the arts of the courtier he won the favor of Sixtus IV, and returned to Spain about 1483, loaded with benefices, among them a prebend in the Toledo cathedral, which excited cupidity and enmity. He was an Old Christian, of pure Biscayan descent, who could not be suspected of Judaism, but he was a loose and inconsiderate chatterer. In the Spain which he had left there was much licence. In the Rome where he had so long sojourned there was more. He could not, on his return, accommodate himself to the new order of things, and his reckless talk gave the opportunity of making vacancies of his numerous preferments. The evidence against him was of the flimsiest. The most serious charge was that, when a tenant had been unable to pay rent on account of the Inquisition, he had petulantly wished it at the devil. At a later period he would have had a chance to purge the evidence by the water torture, but this was not permitted him. He was hurried to the stake as a pertinacious negativo, leaving his spoils to those who could grasp them. It was a well accepted maxim of the civil law that torture should not be employed when the penalty of the crime charged was less severe than the infliction of torture, an equation of suffering which afforded to the doctors ample opportunity of defining the unknown quantity. This was fully accepted by the Inquisition, and we are told that torture is not indicated for propositions merely offensive, rash, scandalous or blasphemous, or for the assertion that simple fornication is not a mortal sin, or for heretical blasphemy or sorcery, or for propositions arising from ignorance, or for bigamy or solicitation in the confessional, or for lying under excommunication for a year, or for other matters which infer only light suspicion of heresy, even though for some of these offences the punishment was scourging and the galleys. Torture is freely alluded to as an irreparable injury, the use of which would be unjustifiable in such matters. This, however, was like everything else in this nebulous region, open to considerable laxity in application. When Francisco de Tornamira, a boy of 18 and page of the Duke of Pastrana, was tried in 1592, on the charge of having said that Jews and Moors could be saved if they had faith in their respective beliefs, he denied and was tortured till he confessed, and then the triviality of his offence was admitted by subjecting him only to abjuration de levi, to hearing a mass as a penitent in the audience chamber, and to a reprimand. The same tribunal in 1579 tried Stefano Grillen, an Italian who, in a discussion with some chance fellow travellers, maintained that the miracles at the shrines of Our Lady of Atocha and of La Caridad were wrought by the Virgin herself and not by her images. He freely confessed but was tortured, apparently on intention, and was dismissed with the same trivial punishment as tornamira. Even more suggestive is the case of Juan Pereira, a boy of 15, tried in 1646 for Judaism at Valladolid. The proceedings were dilatory and he gradually became demented. Nothing could be done with him and opinions were divided as to the reality of his insanity. The Suprema was applied to and sagely ordered torture to find out. It was administered April 22, 1648, but the method of diagnosis was not as successful as its ingenuity deserved and, in August, he was sent to a hospital for 6 months, with instructions to observe him carefully. As his name after this disappears from the records, he probably died in the hospital. It is evident that the Inquisition did not take to heart the warning issued by the Suprema, in 1533, that torture was a very delicate matter. When we come to inquire as to the character of evidence requiring torture for its elucidation, we find how illusory were all the attempts of the legists to lay down absolute rules, and how it all ended in leaving the matter to the discretion of the tribunal. As confession, though desired, was not essential to conviction, the negativo who was convicted on sufficient evidence was not to be tortured but was to be relaxed. Even this rule, however, could be set aside at the caprice of the judge, though he was warned in such cases to put on record a protest that he did not direct the torture against the matters that had been proved, for the very good reason that endurance of torture might purge them and nullify the proof. It was impossible to reduce to a logical formula that which in its essence was illogical, or to frame an accurate definition of evidence that was insufficient for conviction yet sufficient for torture. It was easy to say that semi-plena evidence suffices, but what was semi-plena? One authority will tell us that a single witness, even an accomplice, justifies torture, another that 3 accomplice witnesses are requisite. One impartial and unexceptionable witness, again, is sometimes held to require public fame as an adjuvant, but the records are full of cases in which torture was employed on the unsupported testimony of a single witness. The weight of other more or less confirmatory evidence was also keenly debated, without reaching substantial agreement. Whether flight before arrest, or breaking jail, or vacillation and equivocation when examined, or even pallor, was sufficient justification. It is not surprising, therefore, that, as a practical result, we are told that all these questions must be left to the discretion of the judge, to be decided in each individual case. Under such conditions it would be useless to expect consistency of practice in all tribunals and at all periods. We have seen above that cases were sometimes suspended because evidence had not been ratified, yet the Toledo tribunal in 1584 tortured Lope el Gordo for that very reason, because the chief witness against him had not ratified his testimony, and it is satisfactory to add that Lope endured the torments and thus earned suspension of his case. The diminuto, whose confession did not cover all the adverse evidence, was, according to rule, to be tortured in order to account for the deficiency. If he endured without further admission, he was to be punished on the basis of what he had confessed, but if he did not thus purge the evidence, he was to be sent to the galleys. This was sometimes done in mere surplusage, apparently to gratify the curiosity of the tribunal, as in the Toledo case of Antonio de Andrada in 1585, who confessed what was amply sufficient for his punishment but, as there were some omissions, was tortured to elucidate them. In the 17th century, however, we are assured that there was much caution used in torturing diminutos, and that it was not done unless the omitted matters were such as to call for relaxation. If they concerned accomplices, however, whom the culprit was suspected of shielding, he was tortured in caput alienum. Retraction or vacillation of confession necessarily required torture to reconcile the contradiction. This occurred chiefly with timid persons, frightened by the demand of the fiscal for torture, and thus led to make admissions which they subsequently recalled, thus bringing upon themselves what they had sought to avoid. The question of intention in the performance of acts in themselves indifferent was, as we have seen, the frequent occasion of torture, as there was no other means known to the jurisprudence of the period which was bent on ascertaining the secrets of the offender's mind. Yet it is possible that in some cases, when torture appears to be pure surplusage, there may have been the kindly intention of contributing to the salvation of the sufferer by inducing or confirming his conversion, for habitual persecution for the greater glory of God induced a state of mind precluding all rational intellectual processes where the faith was concerned. Thus Rojas tells us that there should be no hesitation in the use of torture when the salvation of the culprit's soul was involved, so that he might be reconciled to the Church and undergo penance through which he might be saved. This reasoning was urged in the case of René Perot in 1624 by some of the consultores of the Tribunal of Toledo. His crime of maltreating the host was public and unquestionable, but he had varied in his statements as to his faith. The consulta de fe was unanimous in ordering torture to discover possible accomplices, but some of the members desired a special additional torture in order to confirm him in the faith and save his soul. That witnesses should be tortured in order to obtain or confirm their testimony is an abuse which, repulsive as it may seem to us, has been, with more or less disguise, a practice wherever torture has been used. It is true that the Roman law prohibited that one who had admitted his own guilt should be examined as to that of another, and this principle, adopted in the false decretals, became a part of the early canon law. The Inquisition, however, regarded the conviction of a heretic as only the preliminary to forcing him to denounce his associates. The earliest papal utterance in 1252, authorizing its use of torture, prescribed the employment of these means to discover accomplices, and finally Paul IV and Pius V decreed that all who were convicted and confessed should, at the discretion of the inquisitors, be tortured for this purpose. The cuestión prealable or definitive, in which the convict was tortured to make him reveal his associates, became, through the influence of the Inquisition, a part of the criminal jurisprudence of all lands in which torture was employed. It was, in reality, the torture of witnesses, for the criminal's fate had been decided, and he was thus used only to give testimony against others. The Spanish Inquisition was, therefore, only following a general practice when it tortured, in caput alienum, those who had confessed their guilt. No confession was accepted as complete unless it revealed the names of those whom the penitent knew to be guilty of heretical acts. If there was reason to suspect that he was not fully discharging his conscience in this respect, torture was the natural resort. Even the impenitent or the relapsed, who was doomed to relaxation, was thus to be tortured and was to be given clearly to understand that it was as a witness and not as a party, and that his endurance of torture would not save him from the stake. The Instructions of 1561, however, warn inquisitors that in these cases much consideration should be exercised, and torture in caput alienum was rather the exception in Spain than the rule as in Rome. In the case of the negativo, against whom conclusive evidence was had, and who thus was to be condemned without torture, the device of torturing him against his presumable accomplices afforded an opportunity of endeavoring to secure his own confession and conversion. We have seen this fail in 1596 in the Mexican case of Manuel Diaz, nor was it more successful in Lima in 1639 with Enrique de Paz y Mello, although the final outcome was different. He persistently denied through 5 successive publications of evidence, as testimony against him accumulated in the trials of his associates. He was sentenced to relaxation and torture in caput alienum. It was administered with great severity, without overcoming his fortitude, and he persisted through 5 other publications, as fresh evidence was gathered. Yet at midnight, before the auto de fe, in which he was to be burnt, he weakened. He confessed as to himself and others, and his sentence was modified to reconciliation and the galleys, while good use was made of his revelations against 30 of his accomplices. The torture of witnesses who were not themselves under trial was permitted when they varied or retracted, or so contradicted other witnesses that it was deemed necessary thus to ascertain the truth, but whether clerical witnesses could be so treated was a subject of debate. As a rule, torture in such cases was directed to be moderate, neither light nor excessive, but when testimony was revoked it could be repeated up to 3 inflictions. As we have seen above (Vol. 2, page 537), slaves testifying in the cases of their masters could always be tortured, if necessary, to confirm their evidence. In the prosecution of Juan de la Caballeria in 1488, as accessory to the murder of San Pedro Arbues, his slave girl Lucia gave compromising evidence which she was persuaded to retract, with the result that she was twice tortured and confirmed it. Like Majestas, in heresy there were no privileged classes exempt from torture. Nobles were subject to it, and so were ecclesiastics of all ranks, but the latter were to be tortured less severely than laymen, unless the case was very grave, and they were entitled to a clerical torturer if one could be found to perform the office. As in their arrest, so in torture the sentence, by a carta acordada of 1633, had to be submitted to the Suprema for confirmation. As regards age, there seems to have been none that conferred exemption. Llorente, indeed, in describing a case in which a woman of 90 was tortured at Cuenca, says that this was contrary to the orders of the Suprema, which prescribed that the aged should only be placed in conspectu tormentorum, but I have never met with such a rule. In 1540 the Suprema ordered that consideration should be given to the quality and age of the accused and, if advisable, the torture should be very moderate, while the Instructions of 1561, which are very full, impose no limit of age and leave everything to the discretion of the tribunal. Cases are by no means infrequent in which age combined with infirmity is given as a reason for omitting torture or inflicting it with moderation, but age alone offered no exemption. At a Toledo auto de fe we find Isabel Canese, aged 78, who promptly confessed before the torture had proceeded very far, and Isabel de Jaen, aged 80, who at the fifth turn of the cords fainted and was revived with difficulty. In 1607, at Valencia, Jaime Chulela, aged 76, after confessing certain matters, was accused by a new witness of being an alfaqui. This he denied and was duly tortured. Not much more respect was paid to youth. In 1607, at Valencia, Isabel Madalena, a girl of 13, who was vaguely accused of Moorish practices, was tortured, overcame the torture and was penanced with 100 lashes. In the same year the tribunal showed more consideration for Juan de Heredia, a boy of 10 or 11, whom a lying witness accused of going to a house where Moorish doctrines were taught. On his steadfast denial he was sentenced to be placed in conspectu tormentorum, which was carried out in spite of an appeal by his procurator, but he persisted in asserting his innocence and the case was suspended. Mental incapacity, short of insanity, was not often allowed exemption, and it is creditable to the Valencia tribunal that when, about 1710, the Suprema ordered the torture of Joseph Felix for intention with regard to certain propositions, it remonstrated and represented that he was too ignorant to comprehend the object of the torture. End of Section 2. Recording by Shena Ser, Fresno, California.